The ultimate objective of financial remedies on divorce is to achieve fairness. Under the Matrimonial Causes Act, 1973, fairness is measured by three principles: needs, compensation, and sharing. There is a mechanical flaw in this objective. The court cannot divide what it cannot see. In many marriages, a severe information asymmetry develops over time. One spouse often controls the primary capital resources, the business interests, and the financial paperwork. Attempting to negotiate a settlement while this blind spot exists puts the uninformed client at immediate risk of an inequitable outcome. Achieving fairness depends entirely on establishing a state of perfect information. Dividing marital assets is a strict exercise in data verification, long before it becomes an argument over case law. To break this asymmetry, family courts rely on a specific, rigid framework, Part 9 of the Family Procedure Rules, 2010. This procedural machinery revolves around a single document, the financial statement. In practice, it is universally known as Form E. Form E is not merely an administrative checkbox. It is a mandatory, legally binding audit of a person's entire financial existence. It requires total disclosure, removing the margin for voluntary omissions. Mastering Part 9 procedure and the precise anatomy of this document is the foundational requirement for any family law practitioner seeking to protect their client. The timeline starts before proceedings are issued. Parties must attend a MIAM. Once Form A is issued, it triggers a strict countdown. Under FTR Rule 9.14, both parties must exchange Form E exactly 35 days before the first appointment. Crucially, this exchange must happen simultaneously. This synchronization prevents either side from gaining a tactical advantage by waiting to see the opposing party's hand before playing their own. This timeline neutralizes delay tactics. It forces both parties to arrive at the negotiating table with identical levels of transparency. This schematic illustrates Form E. It captures personal history, establishing the timeline. It covers capital resources. Every property and business must be declared. Liabilities are subtracted for net asset value. It projects capital for future needs. Finally, pensions demand formal valuations like a CEV. By prompting for specific asset classes across dozens of fields, the form creates a systematic record that leaves little room for claims of accidental oversight. The court does not take a party's word for the numbers typed into these fields. Verification is mandatory. Specific documentary evidence must be attached to the form. This includes the last 3 months of payslips, recent P60s, and current mortgage statements. All of this data culminates in the final and most critical element of the document, the statement of truth. Signing this statement operationalizes the strict duty of full and frank disclosure for both the client and the practitioner. It transforms Form E from a simple questionnaire into a legally binding declaration, carrying severe penalties if falsified. This is the Supreme Court, which, along with other appellate courts, has repeatedly intervened when the integrity of this disclosure process is breached. In cases like Livesey v. Jenkins and Charland v. Charland, the precedent is clear. A failure to provide frank disclosure can lead to final financial orders being entirely set aside, even years after they were made. The immediate sanctions for hiding assets are steep, ranging from heavy costs penalties to imprisonment for contempt of court. This high-stakes environment creates a practical dilemma. When one spouse suspects the other is hiding assets, the temptation to take matters into their own hands is immense. But the court established a strict boundary in the case of Immerman, specifically regarding self-help. Illicitly seizing or copying a spouse's confidential documents is a breach of confidence and potentially a civil or criminal wrong. Information must be obtained procedurally. While the court demands full and frank disclosure, practitioners must extract that truth strictly through lawful FPR mechanisms, never through illicit client means. Even after a lawful exchange, the raw data within two competing Form Es is often too dense and contradictory for a judge to adjudicate immediately at the first appointment. To solve this, the Financial Remedies Court Efficiency Statement requires legal representatives to consolidate the raw data into standardized forms. Form ES1 creates a joint chronology and case summary, mapping out the agreed facts. Form ES2 creates a joint schedule of assets and liabilities. It places the applicant's and respondent's valuations side by side for direct comparison. These joint documents force opposing counsels to clearly identify exactly where the financial disputes lie, saving critical court time. Navigating financial remedies is a strict exercise in data verification. Part 9 of the Family Procedure Rules and Form E strip away marital opacity, ensuring both parties stand on equal footing. Without the rigorous, truthful execution of this process, equitable division is impossible. Mastery of this procedure is the foundational requirement of family law practice.